What happens on appeal when a Massachusetts divorce court reaches into a Michigan irrevocable trust and pulls out $1.17 million for the ex-son-in-law, despite a spendthrift clause? An independent trustee with sole and absolute discretion. The wife's out-of-state divorce made her mother's divorce-proof trust design the primary funding source for the $1.17 million property division judgment payable to the ex-son-in-law over 10 years. Shouldn't that irrevocable trust interest have been untouchable as separate property? The Massachusetts appellate court had to decide that exact question in the Jones case. Here's the million-dollar problem. Before the divorce, the mother's GRAT had terminated, and the wife's subtrust was funded and running under Michigan law. The independent trustee had the power to postpone every distribution to the wife for her entire lifetime. The feature that was supposed to make her interest a speculative expectancy too remote for any divorce court to reach. But buried in that postponement provision was one verb with the power to decide the appeal. If you advise clients whose families build trusts like this, the Jones appellate result affects your client files, not just this family. In episode 111, Irrevocable Trust Litigation, Busted in Divorce, Son-in-Law Gets $1.17 million, we examine how one verb in a postponement provision challenged the divorce-proof trust design on appeal and analyze the appellate court's reasoning. Join us to see how it litigated.
When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lise Murray, JD, lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong so you get it right. And now, here's your host, Professor Kelly Lise Murray.
I'm Kelly Lise Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We break down actual court cases that impact your professional practice and your clients' wealth outcomes. Let's gavel in. When is an irrevocable GRAT-funded subtrust not irrevocable enough? That's the $1.17 million question in the Jones case, a 2023 Massachusetts appellate decision. On the surface, this irrevocable trust looked irrevocable. It had many of the wealth protection features commonly used, including creditor protection provisions. Irrevocable, governed under Michigan law, not Massachusetts where the divorce occurred. There was an independent trustee with sole and absolute discretion. The mandatory distribution would not occur until the grantor's death, and the grantor in this case was the wife's mother. And throughout the divorce proceedings, the wife's mother was alive. Another factual note to keep in mind is throughout the divorce proceedings, the wife never received a discretionary distribution from the trustee. There was a postponement clause where the trustee could postpone payment to the wife of that mandatory distribution for the remainder of the wife's lifetime, meaning she may never personally receive the mandatory distribution. But we have our first cue of why the divorce court ruled against the wife and in favor of the husband, who was not a beneficiary of this trust. And that was an exception to the spendthrift clause. The exception gave the wife, as the beneficiary of this irrevocable trust, a testamentary power of appointment, even if the trustee delayed paying the mandatory distribution after the grantor's death. The wife, as the beneficiary, retained the testamentary power of appointment. That means she could direct who would inherit her interest. Does that make this irrevocable trust not irrevocable enough? Does that make the wife's interest not speculative, but in fact fixed and divisible in Massachusetts? Jones is not just an irrevocable trust in a divorce case. It's also a client file review opportunity for you. Do you have clients with trusts whose beneficiaries are adult children or adult grandchildren? Are those adult children or grandchildren married? Is there a prenuptial agreement? If it's a GRAT-funded subtrust, has the GRAT terminated yet? Has the subtrust funded? All of those facts come into play in the Jones decision. And then there's the role of a prenuptial agreement. In the Jones case itself, the GRAT was created 2 years before the divorce was filed, over 15 years into the marriage at issue. The irrevocable GRAT-funded subtrust had a provision giving the independent trustee discretion to withhold distributions to a beneficiary who does not have a proper prenuptial agreement. The problem is this interest was created over 15 years into the daughter's marriage, so it had no impact on the daughter's marriage, and there was no prenuptial. But even if your client facts are different, even if your clients have a provision about a prenuptial, that is an important protection, but it is not bulletproof. We'll have a look at that in our takeaways. The Jones timeline gives us a chance to look at the facts and the procedural history, the collision of a Michigan trust and a Massachusetts divorce. This was a 19-year marriage. They had 2 children, and both spouses were employed outside of the home during the marriage. That's important given their lifestyle. The marital standard of living was far above what they earned because of the wife's mother provided monetary gifts, experiences that she funded. And then also in 2015, this is 17 years after the marriage, the mother-in-law created a GRAT. The trial court describes the purpose of the GRAT as a vehicle for transferring money while avoiding federal gift taxes. This GRAT terminated, and upon its termination, the residual in the GRAT itself was divided between 2 beneficiaries in GRAT-funded subtrusts, the mother-in-law's daughter, who's the wife in this divorce, and the mother-in-law's son, who has no role in this divorce at all. That GRAT started in 2015, and one of the wealth protection provisions included the failure to have a proper prenuptial agreement, but it had no impact on the daughter because she was already married at the time the GRAT was created. 2 years later, in March of 2017, the husband filed for divorce, and in March of 2018, while the divorce was pending, the GRAT terminated, and the wife's GRAT-funded subtrust, an irrevocable trust, funded. The question becomes, does that make the irrevocable trust fixed? The wife's interest, is it fixed enough to be marital property? The wife argued the opposite, that her interest remained speculative. We'll have a look at how it worked out on appeal, but at the trial level, the husband prevailed and the wife lost. The trial court held that the wife's interest in this subtrust was sufficiently fixed to be divided as marital property. That was based on a 3-day trial in September of 2019, and the appeal was resolved September of 2023. And if you look at that 5-year period of litigation, you see that the pandemic probably delayed these proceedings. There are 5 issues on appeal. 2 of them we will address straight away. The third follows immediately after this slide, and then we'll spend most of our time on issues 1 and 2. Issue 4 and issue 5 reveal gaps in the record on appeal. This is a lawyer problem. This is a mistake either at the trial level, at the appellate level, or both. Issue number 4, did the trial court abuse its discretion by dividing stock-based assets without accounting for market fluctuations? That sounds bad, doesn't it? That was the wife's argument on appeal. The trial court erred, this is the wife's argument on appeal, by not accounting for market fluctuations when the trial court valued and divided stock-based assets. That issue was omitted from the appellate record, meaning it was presented at the trial level. There was evidence and argument, and the trial court rendered its ruling. But on appeal, the appellate record was missing that evidence and those arguments. That made issue 4 invisible on appeal, and the wife loses procedurally, not substantively. That issue was not addressed substantively. Similarly, issue 5 is another gap, a lawyer problem, but it is a client consequence. Did the trial court abuse its discretion by not accounting for tax consequences? The wife is ordered to pay over a 10-year period to the ex-husband $1.17 million. At the trial level and on appeal, she's arguing that she should not bear the tax consequences because she would have to spend more than $1.17 million if she's the one paying the tax consequences. That issue was missing evidence at the trial level. That's what the appellate court held, that the trial court did not err, rejecting that argument because sufficient evidence was missing at the trial level. Another lawyer problem, but as you can see, each of these lawyer problems, the costs were borne by the client. Issue 3 we will address next, and this is simply, should 3 assets gifted by the wife's mother have been excluded from the marital estate as gifts? Gifts are generally separate property. The trial court ruled that they were marital property. We'll have a look. But the focus of this discussion of the Jones case, the 2023 appellate decision, are issues 1 and 2. Issue 1 was the wife's beneficiary interest in this irrevocable subtrust too speculative to count as marital property. The wife argued that at the trial level and lost. She argued it on appeal. We'll see how that turned out. On issue 2, did Massachusetts or Michigan law govern the wife's indirect interest in Michigan real estate? This is a Michigan trust. The wife also has a separate interest in Michigan real estate, and the Massachusetts trial court applied Massachusetts law to ultimately determine whether any or all of these assets were marital. Now, the trust itself has a choice of law provision, and that's Michigan. Did the trial court err? We'll find out on appeal. This is a direct quote from the trial court, and you can see how it went on appeal just from the phrasing, that the mother-in-law's gifts and the trust wealth that elevated and continued the marital standard of living was already, quote, woven into the fabric of the marriage, close quote. That is not only memorable, it's a new standard woven into the fabric of the marriage. And that's why the trial court held that these gifts were marital, and it's why that issue was affirmed on appeal. The mother-in-law's gifts to the wife included financial accounts in the wife's name used throughout the marriage. That's the woven into the fabric of the marriage piece. This GRAT-funded subtrust. The wife during the marriage and during the divorce never receives any discretionary distributions, but that is held at the trial level to be marital property that gets valued and divided in the husband's favor. The wife also has a 99% interest given to her by her mother in real property. One piece of real estate is the marital house. The mother-in-law, through this LLC, purchases the marital house. This LLC pays the property taxes, it pays for renovations, and it pays for repairs. The family lifestyle well above the earnings. And to their credit, it should be mentioned, they were both employed, but the lifestyle was not limited to their earnings, and it was apparently elevated to such an extent that it made a significant impression on the trial court. Another point that the trial court makes that is quoted on appeal is that the wife minimally saved for retirement and that neither spouse saved anything for the children's college education. The presumption there is that they were expecting the mother-in-law's contributions to continue for both of those issues. Here's what the court wrote. The wife's mother showered the family with gifts. The wife always knew that there was additional money available to meet the family's needs and whims. But for the wife's mother's generosity and this money, the parties would not have been able to maintain the lifestyle they did on their income from employment alone. And that $1.17 million in property division, it was awarded to the husband at the trial level so that he could maintain the marital standard of living for himself and the children. Quick sidebar concerning a GRAT. It rhymes with cat. Its purpose is to reduce gift tax transfer. It has a limited time, and during the GRAT itself, annuity payments are made to the grantor, the settlor. In this case, that was the mother-in-law. For a period of years, she received annuity payments, and at the expiration of the GRAT, under its own terms, the remainder was divided between her son, who is unrelated to this divorce, and her daughter, who is the wife in this divorce. That's why the wife's irrevocable trust was actually a GRAT-funded subtrust. Back to issue 1. Is the wife's interest speculative or is it fixed? If it's fixed, it's marital and it can be divided. Massachusetts is an all-property state, meaning the divorce court can consider not just marital property, but also separate property. And that makes a significant difference in this case. You may think, well, my clients don't live in Massachusetts, or the trust was created in a different state. Well, that is actually factually what happened in Jones. The Michigan trust related to a marriage that started in Michigan. After getting married, they moved to Massachusetts. Portability should be part of your client file review. Where was the trust created? What is its choice of law? Is it Nevada? Is it South Dakota? In this instance, it's Michigan. And if Michigan law had applied, the outcome would have been different. But this marriage didn't divorce in Michigan, even though that's the state it was created in. They divorced in Massachusetts. And Massachusetts has a public policy interest in marital division of assets. Some of the reasons the trial court relied on to conclude that the wife's interest in the irrevocable trust, the GRAT-funded subtrust, was fixed and not speculative. First, the wife was the sole beneficiary. She had sole beneficiary status. It was a closed class. Sounds more fixed and less speculative. Second, that testamentary power of appointment. It was an exception to the spendthrift clause. And it gave the wife, according to the trial court, it gave the wife a present interest in the corpus of the trust, even if the trustee exercised its discretion and postponed paying the mandatory distribution throughout the wife's lifetime. The wife never gets that mandatory distribution. Her estate is still entitled to it, given the testamentary power of appointment that was an exception to the spendthrift clause. And then the third issue here is that the mandatory distribution was not defeated by the postponement clause. This is a separate argument that the wife raised, and we're going to look at the verb choice, what difference one verb made. This one verb may not have changed the result in Jones, but it may have a major impact in your client's trust. Postpone versus terminate. This one verb may change a beneficiary's interest from speculative to fixed and thus marital in a divorce in a state like Massachusetts. And Massachusetts isn't the only all property state. You have Connecticut, New York, and others. But postpone. In this irrevocable trust, the trustee had the power to delay, had the power to postpone the mandatory distribution for the remainder of the wife's lifetime. She may never actually receive that distribution. Factually, the wife's mother is alive throughout this divorce, so there is no mandatory distribution yet, but it is written using shall. The trustee shall make this mandatory distribution after the grantor's death. The trustee had the power to postpone, but as the court pointed out, the verb used was not terminate. The verb was merely postpone. And because postpone is a delay and not divestment, that's how the trial court ruled that the wife's interest in the irrevocable trust was fixed and not speculative. Because it was fixed, it was held to be marital property, valued and divided between the wife and her ex-husband. If the trustee, by contrast, can terminate the beneficiary's interest in the mandatory distribution, makes it not mandatory, doesn't it? If the verb is terminate and not postpone. In this trust, there were specific criteria, including the possibility of a divorce, the failure to have an appropriate prenuptial agreement. Those were reasons that the trustee could postpone the mandatory distribution. Well, what if the trustee could terminate the mandatory distribution, or the beneficiary doesn't qualify as a beneficiary if they don't meet those criteria? That would push the interest to be more speculative and less fixed, more in line with the creditor protection purpose of creating these irrevocable trusts in the first place. This is the appellate court quoting the language of the irrevocable trust. The trust provides that Michigan law governs its validity, construction, and all rights and obligations set forth therein. Under Michigan law, the wife would win. At the trial level in this Massachusetts divorce, the Massachusetts trial court applied Michigan law to a point, but then made the marital property decisions under Massachusetts law. Michigan is not an all property state for purposes of divorce. Massachusetts is. The trust's governing law is Michigan. The divorce's governing law is Massachusetts. And because parts of the trust had to be interpreted under Michigan law, the Massachusetts Appellate Court in footnote 19 relies on an unpublished Michigan decision. And then in footnote 19 correctly points out that an unpublished opinion has no precedential value in Michigan, but may be followed in Michigan if a court finds the reasoning persuasive. Well, this is a Massachusetts court relying on an unpublished Michigan decision with no precedential value in Michigan. The Massachusetts Appellate Court in footnote 19 correctly points out, because there is no other case in Michigan, even though this is not precedential in Michigan or anywhere else, it's Massachusetts' best indication of how Michigan courts would rule in a published case. This is one of the weakest pieces of reasoning in the appellate decision for the Jones case, but it supported the outcome, which was to affirm the irrevocable trust as a fixed interest and thus marital, and affirmed the $1.17 million award payable to the husband over 10 years. Issue 2, trust-owned Michigan real property. Whose law governed? Under Michigan law, the real estate would have been separate property. Under Massachusetts law, it was marital and divided in the divorce. Which brings us to footnote 14, where the math doesn't math. The wife's irrevocable subtrust was valued by the divorce trial court at $1,285,000, so almost $1.3 million. The equalization payment to the husband over 10 years, $1.17 million. If you do the division, the husband is receiving 91.3% of the subtrust's value at the time of the divorce. He's being paid over 10 years, but the amount is 91.3% of the subtrust's value. An important fact that the appellate court emphasizes is that there is no direct transfer of irrevocable trust assets to the son-in-law. He doesn't get any of the assets. Some of these subtrust irrevocable trust features hold, and the assets themselves do not get divided. But where is the wife getting the money to pay $1.17 million over 10 years when the trial court concluded that her salary and his salary didn't even come close to establish or maintain the marital standard of living? The wife's earnings do not give her anywhere near the money she needs to make these payments. At this point in the divorce, she has never received a distribution from the trustee. After divorce, if the trustee, in its sole and absolute discretion, sends any distributions to the wife, the husband has a de facto lien. The trustee cannot make any payments out of this irrevocable trust to the wife without her owing that money to the husband. And that's what the courts knew would happen. But we need to take a look at what the appellate court writes. And I have underlined, nor was there any evidence. That is the kicker. Let's look at the entire paragraph and then go back to that underlined section. This is the appellate court. There has not been any postponement here on these or any other grounds, nor was there any evidence that the wife ever requested or would need to request a distribution in order to make any of the payments to the husband required by the amended judgment of divorce. To the extent that the possibility of divorce provision in the trust was intended to preclude the husband from obtaining any of the trust assets themselves or assets directly traceable thereto, the amended judgment of divorce has not been shown to contravene that intent. Let's translate. The appellate court is basing all of this on there was no evidence that the wife would need to use money from the trust to pay this $1.17 million judgment. There are many attorney-drafted articles concerning the Jones case, and one in particular spends a lot of time on the math. And the sidebar I raise here is simply this. If a law firm reading these appellate decisions can do the math, that means there was evidence in the record to do the math. So let's break this down. Apparently, the specific argument was not made at the trial level that the wife would have to ask the trustee to give her the money to pay over 10 years $1.17 million. According to the appellate court that has seen the record on appeal, which is based on the trial record, that there's no evidence of that. If that is the case, that is another lawyer mistake, and it's another huge financial consequence to the client. The wife and her mother, who created this trust for her daughter's benefit, and 91% of it at the divorce valuation date is going to the ex-son-in-law. But back to this footnote in this paragraph. If there was no evidence of the argument, the facts were still in the record. At the start of the appellate decision in Jones, the court points out on appeal that it is relying on undisputed facts in the appellate record, which is based on the trial record, which means the appellate court acknowledged what all appellate courts can do. Appellate courts can affirm, for example, for any reason supported by the record, even if the trial court did not base its ruling on that reasoning. The appellate court can rely on any facts in the record. Of course, it needs to be in the trial record and then brought up on appeal, otherwise it's invisible on appeal. But these law firms that are writing articles that are using the math, that are showing if you divide the wife's interest valued at the time of the divorce by 1.17 million, the husband's getting over 90% of the divorce value of the trust. The wife's earnings do not come close to being able to afford that kind of payment. Maybe the wife can make the annual payment in year 1, year 2. But by year 5, she has no ability to pay what is owed to the husband over 10 years. The only way she can do it is to get the money from the trustee, but the trustee can say no. What the trustee cannot do is say no to the wife for her request for the money to pay the annual payment that year to the husband. The trustee can say no to that, but the trustee can't separately give the wife any other money for herself. The kicker of all of this is emphasizing a lawyer mistake in this case. Nor was there any evidence that the wife would have to make a distribution, would have to request a distribution to make the payments. If you're trying to make an argument on appeal, you need the evidence in the trial record so that it may remain in the appellate record. How is there no evidence that the math doesn't math, that the wife cannot pay this? This marital standard of living was far above their earnings. Husband's earnings, wife's earnings combined, not even close to the marital standard of living. How is the wife supposed to use her earnings to make a payment that is bringing the husband back up to the marital standard of living? But the kicker is there was no evidence at the trial level that she can't make these payments without relying on the trust. Both courts, the trial court and the appellate court, emphasize that the assets of the trust are not being distributed to the husband, but the practical result of this trial court ruling that was affirmed on appeal, there is no way the wife can make 10 years of payments without asking the trustee for the money, which means the irrevocable trust that has some irrevocable features is being used to make a payment it's not supposed to have to make. And this quote, that there's no evidence she would have to invade the trust, is how the courts get around it in this case. What's our takeaway here? Make sure you put all your efforts into the trial record. Do all of the math. Make those arguments specific. Even if the arguments aren't specific enough, it looks like there was enough math evidence in the record that on appeal, this doesn't hold water. But the appellate court was able to point out that there wasn't evidence that the wife ever requested or would need to request. So they're taking it away from a mathematical equation and looking at facts. This case did not have all of the arguments that would have helped bolster the wife's positioning that the irrevocable trust should not be used to pay property division to the ex-husband 1 year, 10 years, whatever, because it is an irrevocable trust. So some of those wealth protection features did hold, but as a practical matter, did they? Not really, not if the trust itself is funding that $1.17 million. 91.3% of the subtrust value is going to the ex-husband over 10 years. Other critiques written by lawyers, which you should have a look at: the formal distinction that the husband did not get assets, the practical problem, where is the wife getting the money from the trustee, distribution consequences. If there's no distribution, The ex-husband doesn't get paid, but the wife and the children also suffer. And did the trial court or the appellate court think that the trustee would refuse to help the wife and her children at the expense of the ex-husband? And then we have the suggested fix. Many of these articles point out there was no prenuptial in the Jones facts. That is true. But the grat that was created on behalf of the mother-in-law, the wife's mother, but the son-in-law's mother-in-law, in 2015, it did include a provision giving the trustee discretion to postpone the mandatory distribution based on lack of an appropriate prenuptial agreement. In 2015, the wife was already married. That provision did nothing to her factually. But what if that provision had included postnuptial? Who created this grat on behalf of the mother-in-law? It's using commonly relied on terms for irrevocability, creditor protection, needs to be an appropriate prenuptial agreement. It could have easily included there needs to be a postnuptial agreement in order for this to benefit the wife. That would have changed at least a portion of Jones, but it may make an even bigger impact on your clients who are thinking about creating a grat, which when it terminates would be divided into grat-funded subtrusts. Prenuptials. It's bad if you don't have them, but they're not bulletproof if you do. A prenuptial agreement is a backstop, not a force field. Like trusts that may originate in one state and specify choice of law, when the parties are litigating that trust in a different state, the originating choice of law provision may not prevail. We've seen that in episode 107. That's the Dahl case from Utah, DAHL. And that's also what happened here in the Jones case in episode 111. Similarly, prenuptial agreements may specify choice of law. It may be the state where the parties are married, where they signed the prenuptial and then got married. But what if they move and they divorce in a different state? Their different states may not enforce the entire prenuptial or may not enforce it at all. Prenuptials are not perfectly portable. This is a significant risk and a significant legal issue. Bottom line, prenuptials are bad to not have, but they're not bulletproof even when you do require them. The concept of divorce-proof trust design, that is why many irrevocable trusts have been created, especially by third parties. This could be the parents or the grandparents. So the parents of adult children with adult grandchildren may create a trust, or even generation skipping, and include irrevocability factors, spendthrift provisions, other creditor protection provisions. But constructing it is not the same thing as litigating it, especially when the states change, when the trust is created, as here in Michigan, when they were married in Michigan, but then it's divorcing in Massachusetts. Very different law with a very different outcome. What's happened since 2023? Quite a bit. One case to look at is in New York, which, like Massachusetts, is an all-property state. Add to that list Connecticut and Indiana and others. In this 2025 New York divorce, it's an ultra high net worth divorce. During the marriage, the husband created irrevocable trusts where the husband and wife were not beneficiaries. In the divorce, he claimed that it was not marital, that the court had no jurisdiction over the irrevocable trusts. And if you have a look at episode 107 of Wealth Litigated podcast, we detailed the Dahl case in DAHL. That was a divorce in Utah with an irrevocable trust governed under Nevada. That court held the power to amend the irrevocable trust made it revocable and thus marital property. And that Dahl case included marital assets. Now, in that same episode 107, we talked about the Oaks case, which is from Ohio, and that case had the opposite result. An irrevocable trust created during the marriage with both spouses' knowledge. The husband was the trustee. The wife was a beneficiary only while married to the husband. Upon divorce, she would no longer be a beneficiary, and that appellate decision ultimately concluded that irrevocable trust remained irrevocable, and the marital property gifted into the trust was not going to be divided at divorce. But the trial court made up for it because that was a high net worth divorce. They had significant assets, and the wife was granted an offset, even though the marital house that was transferred to that irrevocable trust that remained irrevocable and was not marital property, the wife got the value out of other assets. Here in this 2025 New York divorce case, these irrevocable trusts were funded with marital assets. And if the trial court did not hold that the husband's de facto control rendered those trusts marital, the wife would have lost significant marital property because it was transferred into irrevocable trusts. There's a quote from this case that I want to point out because this is how courts look at credibility. In this 2025 New York case, one spouse was specifically held to be fully credible, fully cooperative, and the other spouse was held to be the opposite. And that's the spouse who happened to be pulling these financial shenanigans with the marital property. But this is what the trial court wrote. The divorce proceedings did not need to be acrimonious, and the financial issues could and should have been resolved. There is wealth enough for everyone. What the trial court meant is this should have been resolved at mediation. This is not $5 million. This is hundreds of millions of dollars in assets. What do you think? If you were the judge, how would you view disputes over hundreds of millions of dollars, which if you divide it by 2, everyone still may have hundreds of millions of dollars? Cases after 2023 with the opposite result. These are cases that excluded trusts from the divorce. This is what the wife in Jones was litigating for at the trial level and on appeal. She lost at the trial level. She lost on appeal. The case to start with is from New Jersey because it was also a GRAT subtrust. This is a 2024 New Jersey decision. And many of the facts are similar to Jones with the opposite result. But the main fact is different. This was a GRAT subtrust that had not yet funded at the time of divorce. Even if the same law was applied to this New Jersey case as in Jones, that fact makes a huge difference. If the GRAT is not yet funded at the time of the divorce, the interest may not be fixed. Maybe. That's part of the holding in New Jersey. Additionally, this is the wife's parents who have set up the GRAT, which hasn't terminated yet, hasn't funded the wife's subtrust, and the wife and her children are not entitled to any distributions until each of them is 65 years old. Interests were not marital at the time of this divorce, according to the holding in the New Jersey 2024 decision. Opposite facts also exist in this New Jersey case, where the marital lifestyle was supported from the grandparents' gifts and personal funds and not the trust. Well, we saw in the Jones case that the mother-in-law's gifts and funding of experiences and no distributions were actually made from the irrevocable GRAT funded subtrust. Those facts actually were held against the wife in Jones. They were held in favor of the wife in the New Jersey case. 2 more cases to talk about. Connecticut 2025, this is Netter v. Netter. One trust was excluded from the marital estate. One trust was included. The trust that was excluded was a premarital third-party trust from the husband's parents. The grantor was the husband's father, and the trust was governed by South Dakota law. The husband's interest was held to be a mere expectancy, not fixed, and thus not marital. But self-settled trusts, trusts that the husband created, funded with marital property, was held to be included in the marital estate and divided between the husband and the wife. And what he had done was held to be dissipation of marital assets. The court held that the husband actively tried to reduce the marital estate, and that was undone. Also, these trusts that he created failed to qualify for the Connecticut Qualified Dispositions in Trust Act, which also helped undo the transfer of assets. 2024 Colorado decision. Colorado has a statute excluding discretionary trusts from marital property. And because the trust at issue was a discretionary trust, it was, under the statute, excluded from property division in the divorce. Some takeaways from the Jones case in 2023 and the cases after 2023. A mandatory distribution with a sole beneficiary and a closed class looks a lot more like a vested interest, which in some states may be marital and thus divided in property division. Pure discretion. The Jones court held that the irrevocable trust was not a pure discretionary trust, but with a pure discretion trust, open class, And revocable interest, that's a mere expectancy that is speculative, not fixed, not marital. Like Colorado, Delaware has a statute, this is from 2025, that a discretionary interest is a mere expectancy and not a property right. Because that has been codified in a statute, there is far less wiggle room for any divorce trial court or any appellate court on that issue. All property states are different from states that are not all property in divorce. If your clients live in all property states like Massachusetts or Connecticut, that may have a result closer to Jones than states that are not all property like Michigan. What makes the Jones result especially dangerous is that the factors stacked against the wife. There may not have been one way for the wife to prevail, meaning change one thing and the whole result is different. But for your clients, the opposite may be true. The one verb that's chosen, the one structure that's chosen or not chosen may be what turns an irrevocable trust and the beneficiary's interest from a mere expectancy to fixed and thus marital and thus divisible in a divorce in a state different from the law governing the trust. This GRAT subtrust was funded at the time of the divorce. The GRAT itself was created 2 years before the divorce was filed, and 1 year into the divorce proceedings is when the subtrust funded after the GRAT terminated. That sole beneficiary, that closed class. The mandatory distribution language. The wife was not divested from the mandatory distribution, even though the trustee could postpone paying the mandatory distribution until after the wife herself had died. Because of that exception to the spendthrift clause, that the wife retained the testamentary power of appointment, even if the trustee validly delayed the mandatory distribution, the wife could direct who would inherit it in her stead. And that became a fixed interest. Her estate could not be divested of that interest. Postponement of payment is not termination or divestment. The spendthrift provision intentionally included, and then it was diluted with this power of appointment. Bottom line, Jones and the cases since 2023 provide you an opportunity to stress test your client files. Which of your clients are considering GRAT trusts and GRAT funded subtrusts? Which of those subtrusts are not yet funded or are funded? Which state's law governs the trust, and where does the beneficiary of those trusts live? Because if they divorce in a state like Massachusetts, the result will be different than if they divorced in a state like Michigan. Another takeaway from the Jones case is this: when your clients are creating irrevocable trusts for wealth protection, without looking at how these cases actually litigate, you and your clients are flying blind. These are some of your client file takeaways this week. Which of your clients have created trusts for their children or grandchildren who are adults? Are those adult children and grandchildren married, about to be married? Do those trusts require the beneficiary to have an appropriate prenuptial? What about an appropriate postnuptial? Because if the trust is created after the marriage, the prenuptial provision does nothing, but a postnuptial provision could be helpful. Remember, prenuptial, postnuptial, bad to omit, not bulletproof when you include. GRAT subtrusts. When does the GRAT terminate? When does the subtrust fund? We saw in the New Jersey case, because the subtrust had not yet funded, the wife's interest was speculative, not fixed, not marital. The opposite happened in Jones, but that GRAT funded subtrust had actually funded while the divorce was pending. Sole beneficiary trusts, closed class trusts, both of those lean towards fixed interest, which is marital and divisible in divorce, and not speculative. Mandatory distribution. Well, that defeats the trustee's discretion and renders a trust not purely discretionary. That's one of the factors in the Jones decision. Postponement is a delay. It is not divestment. If the trustee cannot divest the beneficiary's interest and merely postpone, combined with that testamentary power of appointment, that supported the trial court's decision in Jones and the appellate court's affirmance that the wife's interest could not be divested. Even if she never received the mandatory distribution during her lifetime, her estate would. Ultimately, the divorce forum risk on two issues: irrevocable trusts, prenuptial and postnuptial interpretation and enforcement. The Jones case from 2023 and the cases after 2023, these are client conversations you should be initiating this week. Thank you for joining us. Stay tuned for a preview of our next episode. What happens when an ex-spouse and a current spouse both claim to be the spouse for an irrevocable family trust? Here's the problem. One word. Spouse. The mother-in-law's irrevocable trust included her son's spouse as a beneficiary, but never used the word current, never used the word former, and only named her daughter-in-law as a backup trustee. After the son divorced and remarried, his mother, the grantor, died. And suddenly two people, an ex-wife from a 30-year marriage and a current wife in a 3-year marriage, both claimed the same beneficiary status as spouse. When does a trust beneficiary status become a specific person? When it's written or when it's distributed? And is divorce enough to disqualify an ex-spouse in an irrevocable family trust? The Texas Court of Appeals had to decide what one word, spouse, meant in the OXA case. If you work with blended families who have estate plans written before divorce or remarriage, the OXA results affect your client files, not just this family. In episode 112, ex-wife number 1 versus current wife number 2, who's the spouse for the irrevocable trust, we examine how one word pulled two people into the same beneficiary status, explore what determined whether a spouse is a person or a status, and analyze the appellate court's reasoning whether divorce and remarriage rewrite a mother-in-law's irrevocable trust. Join us to see how it litigated, and subscribe so you don't miss an episode.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.